Good morning. Earlier today, the Department of Justice, joined by 29 states and the District of Columbia, sued Live Nation Entertainment and its wholly owned subsidiary, Ticketmaster, for violating the Sherman Antitrust Act. In recent years,
long-term exclusive ticketing contracts, serial acquisitions of regional competitors, and threatening to retaliate against venues. Today's lawsuit by the Justice Department's Antitrust Division is an enormous step forward in preventing one company from dictating the ebbs and flows of an entire industry. It's a step forward to give more venues, promoters, and ticket sellers a chance to compete for the biggest shows. And it's a step forward in making this era of live music more accessible for the fans, the artists, and the industry that supports them. Because when families want to attend a concert, the add-on fees they need to pay shouldn't break the bank. When an independent venue wants to host the next big show, they should have the opportunity to compete. And when a regional promoter wants to publicize an artist, they shouldn't have to fear retaliation. Put simply, one company should not have the power to determine who gets to participate in a marketplace. I want to thank the women and men of the Antitrust Division for their work and Assistant Attorney General Cantor for his leadership to protect consumers, performers, and small businesses. Today and always, their work forms part of the foundation of the department's corporate enforcement mission to promote fairness, to drive deterrence, and to advance the rule of law. Thank you. And with that, I'll turn it over to Assistant Attorney General Cantor.
Thank you, Attorney General Garland and Deputy Attorney General Monaco. The live music industry in America is broken because Live Nation Ticketmaster abuses its illegal monopoly. Today, the United States and 30 state attorneys general filed an antitrust lawsuit that seeks to restore competition by breaking up Live Nation Ticketmaster. The recipe for live music includes three key ingredients: artists, venues, and fans. Live Nation Ticketmaster's dominance has allowed it to exert control over all three. Starts with power over artists. Today, Live Nation Ticketmaster represents hundreds of artists through its dominant promotions business, which controls the organizing, marketing, and financing of large concerts. Live Nation Ticketmaster also owns or controls venues at which these concerts are held. For example, it owns 60 of America's 100 large amphitheaters. At these venues, Live Nation Ticketmaster not only earns money from tickets and fees, but also from concessions, merchandise, sponsorships, and even parking. And through its Ticketmaster subsidiary, Live Nation controls primary ticketing at hundreds of other venues across the country. And it is through these exclusive ticketing arrangements that Americans face the dreaded Ticketmaster tax, the seemingly endless set of fees, ironically named service fee or convenience fee, when they're anything but. Our lawsuit explains through detailed allegations how Live Nation Ticketmaster weaponized and entrenched its power at the expense of artists and music fans across the entire country. Just by way of example, the lawsuit alleges how Live Nation Ticketmaster sought to avoid expensive bidding wars that would have returned more money to performers. This is bad news for all artists, but it is especially bad news for working musicians who do not have the power to fight back. Despite its already massive size and power, Live Nation Ticketmaster has acquired even small and regional promoters that Live Nation feared could one day threaten its dominance. As the complaint also alleges, Live Nation Ticketmaster threatens and retaliates against venues that try to choose a different promoter or ticketer. If you're an artist, you understand what's at stake. Use Live Nation for promotion or risk being locked out. In its own words, Live Nation uses its exclusionary conduct as a, quote, hedge against significant improvements by the competition or even a new competitor, end quote. But the cost of that hedge is one that we all pay. For example, a broken ticketing website with substandard customer service that still captures your valuable data. As Ticketmaster has said, quote, now we not only know the person that bought the ticket, but also the 3 people that you are taking to the show. Each of these acts are unlawful on its own, but taken together, they're even worse. Collectively, these practices forge an impenetrable corporate barrier around the live music industry. That is why with today's lawsuit, we seek to hold Live Nation Ticketmaster accountable for violating the antitrust laws. The legendary songwriter Harlan Howard famously described American music as 3 chords and the truth. This is more than just a clever turn of phrase. It speaks to the importance of music to free speech and the public discourse. Mr. Howard was right. Words and music come together to create one of our country's most cherished forms of free expression. Music is the soundtrack for our lives. As a country, it is how we communicate about politics, love and despair, spirituality, humor, pain, joy, and everything in between. It is here, there, and everywhere. Live music should not be available only to those who can afford to pay the Ticketmaster tax. We are here today to fight for competition so that we can reopen the doors to the live music industry for all. In closing, I would like to thank the Antitrust Division and the staff who today are the rock stars performing to the delight of an entire nation. I would also like to thank the attorneys general and their amazing staffs from the states of Arizona, Arkansas, California, Colorado, Connecticut, the District of Columbia, Florida, Illinois, Maryland, Massachusetts, Michigan, Minnesota, Nevada, New Hampshire, New Jersey, New York, North Carolina, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, Tennessee, Texas, Virginia, Washington, West Virginia, Wisconsin, and Wyoming. They join us today in filing this important and historic case. Thank you.
One on topic and one off topic. I don't know who can answer the question, but when we talk about the Ticketmaster tax and these add-on fees, are we talking about tens of dollars or hundreds of dollars in terms of the average consumer?
It's a good question, which I'm going to give to Mr. Cantor.
I think you need to ask consumers what they think of the taxes that they're paying and the fees that they're paying. At the end of the day, in the aggregate, this amounts to billions of dollars in value across the entire country and across the entire industry.
Mr. Attorney General, with information coming out that the Supreme Court Justice has had a flag associated with the Stop the Steal movement flying over his property, and with 2 January 6th related cases before the court, do you have any concerns, and is there anything the Justice Department can do or say about the situation?
As you rightly point out, the Justice Department has cases before the Supreme Court, so I can't comment on any justice.
We rarely see the DOJ at this phase of enforcement clearly state what kind of remedies it would be looking for in terms of an antitrust case. In this case, however, it's very clear that DOJ is seeking to break up Ticketmaster, Live Nation. Why did you decide to make this so clear at this moment in time, and what kind of remedy or potential breakup would satisfy basically the thinking of the DOJ in this case?
Well, I'm going to leave the floor answer to the Assistant Attorney General, but as the complaint describes, Ticketmaster is an important element in the gears. I think they describe it as the flywheel of the operation, and it's necessary to separate Ticketmaster from Live Nation to limit the overall dominance of the industry and all the effects on consumers, fans, promoters, artists that we talked about. But I'm going to let Jonathan say more.
Some monopolies are just so entrenched and some problems so difficult to address that they require decisive and effective solutions. We request a remedy that has been used in antitrust law going back over 100 years, which is structural relief.
I have two questions for the Attorney General, neither of them on topic.
I'm surprised.
I got most of us got a solicitation email this morning from the former President of the United States saying that the Justice Department had authorization to kill him during the Mar-a-Lago raid. First, can you give us some clarification on that particular point that he's making and whether or not deadly force is authorized in other interventions, including the search of Mr. Biden's residence and office? And the second question is,
Can I do one at a time? Okay. On that one, that allegation is false, and it is extremely dangerous. The document that is being referred to in the allegation is the Justice Department's standard policy limiting the use of force. As the FBI advises, it is part of the standard operations plan for searches, and in fact, it was even used in the consensual search of President Biden's home.
The second question is, obviously, the House appears poised to move ahead with the contempt resolution on you. I just wonder if you have any comments on it, or if you could tell us whether or not you watched the House Oversight Committee meeting the other night.
I caught part of that hearing on Saturday Night Live. But seriously, I am very disappointed. The Justice Department, as I've explained before, has gone to extraordinary lengths to accommodate the legitimate interests of the committees. I have released the full and unredacted report of Mr. Herr. We permitted Mr. Herr to testify for over 5 hours on everything that happened in connection with this investigation, and we provided the transcripts of the interviews in which the committee is interested. But on the other side, the President of the United States has asserted executive privilege in order to protect the Justice Department's ability in future investigations to get cooperation in high-profile cases, particularly involving the White House. My job is to protect the Justice Department's ability to conduct those investigations. My job is to protect the rule of law, and that's what I'm doing.
Last question, Caitlin. General Garland, I have two questions. The first was the Justice Department approval of the Live Nation and Ticketmaster merger back in 2010 a mistake? And then a different topic.
Let's do one at a time.
Okay.
Unless they're both on topic, in which I'm going to punt them to Mr. Cantor anyway. Is the other one also on topic or off topic?
It's a different topic.
Okay. So on that one, I think our complaint adequately describes the reason why that did not resolve the matter as far as we are concerned. But I'm going to let Mr. Cantor say a little bit more, and then I'll come back for you.
The previous action involved one transaction. The current action involves a systemic and systematic pattern of anti-competitive conduct that addresses nearly every aspect of the live music supply chain. The previous action involved the Clayton Act, specifically Section 7 of the Clayton Act. The current action involves the Sherman Act, monopolization under Sections 1 and Section 2 of the Sherman Act.
And then, General Garland, the Justice Department has said that in court multiple times that voters deserve a quick resolution to the cases against Donald Trump. If that does not happen and there is not a resolution or any trial before the election, would that be a failure of justice?
The Justice Department's position is to seek a speedy trial. That matter is now in the hands of the courts. I'm not going to speculate any further.